What if I told you that there's a state that effectively hung up a constitution-free zone at their border? That would be surprising. What would be less surprising is if I told you it's California, because it is. But there are 9 states in total that are doing the same thing California is. We're talking about the Second Amendment. We're talking about constitution-free zones. Guys, let's get into it. So what are we talking about? We're talking about the fact that California and 9 states in total refuse to recognize any out-of-state concealed carry license. Moreover, to my knowledge, you are not allowed to apply for a concealed carry license from that state if you're not a resident or meet a handful of other reasonably stringent criteria. Meaning you cannot conceal carry a handgun or any other weapon, I suppose, if you are in one of these 9 states. End result? Congratulations, you've created a constitution-free zone. Imagine if we did this for free speech. In order to exercise your right to free speech, first you have to get a permit, but oh, rats. Only residents can get permits, so I guess you can't get it unless you want to move here and pay our taxes. Kind of an interesting little setup that they've got there, isn't it? It's as if the Bill of Rights is some sort of local club membership, valid only within certain state lines. You could be a model citizen in Florida, Texas, even New York, but you cannot exercise the same rights when you enter California. And I mentioned that California is far from being alone. We're also talking about New York, Oregon, Connecticut, Massachusetts, Maryland, Hawaii, Illinois, and Rhode Island all have similar laws. That's right. As I mentioned, 9 states in total. And each one of those states is basically excluding upwards of 90% or more of the United States population from being able to practice a core constitutional right within their borders. That is, until we're talking about a lawsuit, Hoffman versus Bonta. So this lawsuit is brought to you by our good friends over at the Firearms Policy Coalition, FPC, who fired up their famous lawsuit printer, along with 3 individuals, Mr. Hoffman from Pennsylvania, Oren from Idaho, and Sensiba from New Mexico. I apologize if I'm mispronouncing any of those names, but residents from Pennsylvania, Idaho, and New Mexico, together with FPC, teamed up to sue over California's law that blatantly violates not only the Second Amendment, but we're actually talking about the 14th Amendment, the Privileges and Immunities Clause, all this other stuff. Or in other words, hey, we're Americans and our rights don't stop at your state line. Now, you might expect if California is going to enact a crazy law like this, that they better have a dang good reason for it. Now, you and I probably know there's no such thing as a good reason when it comes to violating people's core constitutional rights, but at least they may have, put in the effort to come up with something, right? Maybe something along the lines of some sort of founding era law that says that thou shalt not let Pennsylvanians carry arms into Ohio or California or Virginia, if we're sticking with the original 13 colonies. But you get it. Some sort of premise for them to hang their hat on. The right to keep and bear arms shall not be infringed unless you're in California. Something like that. But spoiler alert, there isn't. The judge used the Supreme Court's Bruen test. That's the June of 2022 United States Supreme Court case to come out. It's a 2-part test. This is what's used to examine whether or not gun laws are going to be found constitutional and they can remain, or unconstitutional and see you later. Step 1, does the Second Amendment cover this conduct? The conduct that is being regulated by the law? If the answer is no, it doesn't protect, then okay, it's not a Second Amendment protected case, and now we're back into some other test. But if the answer is yes, you then proceed to step 2. Step 2 is whether or not there is a historical tradition of this kind of restriction. So California needs to find from the historical records, generally at least from the 1800s. If you're pro-gun, you're arguing early 1800s to 1700s. If you're super anti-gun, we're talking late 1800s, especially if you can get into the 1880s, 1890s, when there was an explosion of oftentimes very gun control law that popped up around the country. And if you're anti-gun, man, you want the good stuff. You want the things that targeted Catholics, that targeted Native Americans, that targeted blacks and different people from different political and ethnic groups that were coming in from Eastern and Southern Europe. Those are the laws that you love and want to uphold today, anti-gunners. You should own that. So if California can find something from our nation's tradition that is representative of the tradition and compare that closely to the laws that they have now, then good to go, probably. If they can't, then they should lose. So what did California do? California's best evidence was, well, not great. There are some 19th century laws, a few traveler exceptions, and a lot of basically hand-waving. The judge said, nice try, but no. There's no tradition of wholesale bans on non-residents applying for gun licenses. The state's argument essentially boiled down to, but it's really inconvenient to process applications from people who don't live here, when people, of course, are trying to get applications to California so they can carry when they visit. Yeah. The judge's answer, administrative inconvenience is not a constitutional principle. If it were, the Bill of Rights would be about 3 sentences long. So what did the judge do? The judge granted what's called summary judgment for the plaintiffs. Translation, California's residency requirement for CCW licenses is unconstitutional. The state must let non-residents apply, just the same as residents. Why? Because my rights as a Wisconsin resident don't stop at the California border, or the Illinois border too, I would like to add. And the judge even mentioned the fact that, look, you can charge out-of-state residents a slightly higher fee or something like that. That's fine, but you can't just ban it for everyone. That is out. Big picture, we're not just talking about California. Yes, this is only pertaining to the California law. And yes, I'm not suggesting that you can apply for concealed carry license now if you're a non-resident of California. Why? Because bluntly, they don't have a process or procedure or anything like this. So we're in a little bit of a chaos zone, and rest assured, you know California is going to be appealing this to the Ninth Circuit Court of Appeals. So we've got a ways to go on this, but this is still a big win. It's not only a big win for people who want to visit California, it's a big win for folks who live next to or want to travel to one of the other 9 states that has the same restrictions. It's a big win and a shot across the bow of, I'm sure, a bunch of other states who are considering similar restrictions. But most of all, it's a big win for the Second Amendment in general, showing that there's no such thing as a constitution-free zone yet again. So I'll try to keep you updated on what kind of injunctive relief. The parties have 30 days, yada, yada, yada. Like I said, it's probably going to go up, so just sit tight. One other quick thing that I want to highlight for you is we're talking about some stuff we have not talked about before. We're talking about privileges and immunities clause. We're talking about the 14th Amendment. These are legal concepts and ideas that are meant to safeguard equal protection under law, that a citizen from one state can go to another state and be treated the same. You haven't heard this type of argument before. You haven't heard these topics come up because, bluntly, we've been on the back foot on the Second Amendment. The new topics are coming up because that's no longer happening. We're starting to go on the offense more and more and more. This is no longer throwing the enemy out from inside the castle walls. Now we're starting to go outside the castle walls. So I think increasingly, you're going to hear new topics, new legal ideas come up, and it's important to understand the why. That is the why, because we are winning brick by brick, one step at a time. But this sort of winning doesn't happen by itself. It happens with great groups like FPC, GOA, SAC, FRAC, National Association for Gun Rights, and others who are out there leading the charge, being the tip of the spear, and they can only do it with your support. Now we're going to pivot to our ever popular quote of the day. Be sure to hit that like button, share, and let me know down below, what do you think is going to happen? Remember, the Ninth Circuit Court of Appeals no longer is a slam dunk anti-gun. We just got, and I recently covered, a pro-gun outcome that came from the Ninth Circuit, where actually an Obama judge sided with the 2 Trump appointees from his first term. People, the tide is turning, and elections have consequences. Keep that in mind. Let me know down below in the comment section, in the discussion field, what you think is going to be the outcome for this, not only for California, but for these sorts of laws nationally. Where do you think this is all going to go? And let me know if you want me to go more down the rabbit hole into looking at what type of other constitution-free laws might be out there when it comes to the Second Amendment. What other laws, what other rights are being violated as a result of what California and these other states are looking at? Let me know. Our quote of the day comes from Roman thinker-philosopher Seneca, who said, quote, "Luck is what happens when preparation meets opportunity. And outcomes like this are what happens when preparation, by having great groups, backed by great people like you, find their way into the courtroom." How about that? I appreciate you sticking with me, and I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.